The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to give us a call at 414-253-2080. That's 414-253-2080. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We can also serve you completely virtually. Please enjoy the video.
Hello, this is Matt with Learn About Law. And in this video, I'm going to discuss Wisconsin estate planning laws in 2022. In the state of Wisconsin, for a will to be valid, it must be executed by a testator, which is the person who is creating the will. The will must be in the testator's own writing, and the testator must sign and date the will. Most importantly, there must be two witnesses who witness you executing the will, and the witnesses must sign the will. The witnesses can sign the will after they witness the testator sign the will. In the state of Wisconsin, you can make changes to your will. If you wish to do this, you must create what is known as a codicil. A codicil is validly executed when the testator complies with the same rules as creating a will. You can revoke the will by doing any act that shows your intent to terminate the will, which includes burning, tearing apart, scratching out the will. Once you effectively revoke your will, you can create a new will which will direct your current wishes. A will is a very important document that must be kept in safe condition. It is advisable to place the will in a safe deposit box. You can purchase one from a bank or keep one in your home. You may register your will in the probate court for the county in which you reside. In the state of Wisconsin, your will can be challenged by a showing of undue influence. Undue influence or duress, that at the time of the execution of your will you were susceptible to being subjected to undue influence by the person who is alleged to have committed undue influence upon you while you created your will. It must be proven the person that is alleged to have committed undue influence over the testator had an opportunity to commit undue influence over the testator. It must be shown that the person alleged to have committed the undue influence of the testator had a willingness to take from the testator's estate by doing something that would be considered to be wrong or unfair. It must be shown that the result was caused by the undue influence. The court must find that the person alleged to have committed the undue influence was expected to be excluded from the testator's bounty, and whether or not the result was caused by undue influence, and that this was an unnatural result. The court will look to see if it was unnatural by looking at all of the facts and circumstances. If you happen to die without a will, you die in what is legally known as dying intestate, which means for you, legally, the court will appoint what is known as a personal representative of your estate, whose job will be to distribute your entire estate to your spouse who survives you. If you die intestate with a will in the state of Wisconsin, you are at the court's mercy, in which a Wisconsin family court judge will decide who will raise your children. This person is called the guardian. A will that was created in another state will be valid in the state of Wisconsin if the will complies with the state of Wisconsin will requirements that are listed in the article below. A will also will be valid if it is valid in the state where you signed, or if you are staying there, or if you were living there. Either situation suffices. A trust created by a will in the state of Wisconsin is where you can utilize your will and create a trust upon your death, which will hold your property for the trust beneficiary or trust beneficiaries in the state of Wisconsin. What happens is that you will name a trustee to manage the trust. The trustee can be anybody you choose or a bank or trust company. The trustee owes duties to the beneficiaries of the trust and is responsible for protecting the trust assets, paying the trust beneficiaries' income earned from the trust, financially managing the trust, and terminating the trust in accordance with the terms of the trust. A living trust in the state of Wisconsin is a trust that controls your property while you are alive. When you pass away, the trustee controls the property upon your death. As long as you are alive, you are the trustee of the trust, and the trust's property is treated as if you still owned the property. You will essentially sign paperwork that will give property to the trust. In the state of Wisconsin, in the event that you become mentally or physically incapacitated, you will want to plan ahead for this situation by creating a durable power of attorney. A durable power of attorney appoints a person who is named as your agent to act on your behalf for your financial matters. The durable power of attorney documents lays out the agent's rights to act on your behalf and will give the terms and conditions of the amount of power the agent will have to act on your behalf. These rights will include the authority to sign legal documents, to pay your bills, to buy and sell real property, and to take other actions on your behalf that pertain to your financial dealings. In Wisconsin, a durable power of attorney for health care authorizes your agent to make health care decisions for you when you are unable to do so by becoming mentally or physically incapacitated. If you become incapacitated and are unable to make decisions for yourself and do not have a durable power of attorney, you will then need to ask the Wisconsin probate courts to appoint a guardian for you. Appointing a guardian for you is a very time-consuming task that can take a long time to complete. When you agree to act as an agent under a durable power of attorney, you act as a fiduciary to the principal. This means that you have a legal duty to act in the highest good faith for the principal's benefit. Thanks for watching. To learn more, check out the article linked below. Be sure to leave any questions you have in the comment section, and subscribe for more legal content daily.
Hi again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, I'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please don't hesitate to reach out to schedule a consultation. Most consultations are free and can be conducted remotely if you'd like. You can email us, book online, or call us at 414-253-2080. That's 414-253-2080. We have many locations for your convenience and we serve all of Wisconsin. Thanks again for watching.